In one of our previous videos in the Land Governance series, we spoke about the Registration Act 1908, which is the primary legislation governing the registration of land in India. In this video, we will be looking at Section 22 and the insertion of Section 22A in depth and why it has relevance today. Section 22 of the Registration Act 1908 is a description of lands or houses by reference to government maps or surveys. Section 22A was inserted first in the Andhra Pradesh Registration Act in 1999, and some other state governments amended their laws subsequently. According to Section 22A, the documents for lands that are against public policy may not be registered. Here, what constitutes documents against public policy is left to the discretion of the state government. This may have been done to protect the government lands from illegal encroachment and free it up for serving public interest schemes. States like Andhra Pradesh, Bihar, Gujarat, Tamil Nadu, West Bengal, Orissa, Rajasthan, Maharashtra, and Karnataka amended their state legislation with 22A. However, Karnataka High Court later struck down the amendment after hearing petitions asking to declare the enactment illegal and unconstitutional. The petitioners said that the government has no authority to regulate registrations if the appropriate provisions for it were not laid down in the legislation. The state government defended their position, saying that this is meant to help the sub-registrars across the state to prevent illegal transactions. But the High Court struck down the amendment, citing that the reason is not enough. In 2010, Maharashtra government also amended the Registration Act, deleting the 22A section, the reason for which is unclear. In recent times, Section 22A is back in the limelight because of an ongoing issue in Andhra Pradesh. Following the amendment and insertion of 22A, a High Court order was passed in 2014, and the then AP government had passed a government order citing that all government lands that have been encroached upon be listed under Section 22A, prohibiting the sale and fresh registration of these listed lands. This was updated on the 1B land records on the Me Seva website, and citizens of AP could put in their land details to check the validity of their plots. Many citizens learned that their lands had been allegedly falsely notified under the Section 22A list. Out of this, many had been living in these lands for years and had it registered legally with the appropriate documents. In many cases, the possessors of the lands had been issued pattas under the regularization schemes in the previous years. Citizens have come forward with complaints that they were unable to sell or mortgage their lands as the transfer of ownership of their lands are now prohibited. Many of these cases came from Visakhapatnam district alone. In view of this issue, the state government has asked the district collectors for an explanation for this confusion. At the same time, Andhra Pradesh is also mired in other land controversies along with land pooling in Visakhapatnam. The state government has constituted a special investigation team to investigate these land scams in the district. In March this year, the SIT said that of the examined applications, some were wrongly classified under 22A, but many have grossly violated the 22A norms and are illegal encroachers of the land. Many of these lands, classified as the government lands, were excesses from the Land Ceiling Act 1976. Some of these lands have even been transferred 3 to 4 times among different parties. This whole issue is allegedly due to collusion among revenue officials and real estate dealers or other buyers. At present, complete details of this issue in Andhra Pradesh are unclear, as at the same time, other issues regarding land pooling are also underway. This has made the land scenario in Andhra Pradesh very complicated and covered in controversy. Section 22A has brought in many of these issues, the same act that has been removed in certain states owing to the ambiguities in the legislation. Many other states have not even incorporated the enactment in their state legislation. This controversial amendment has created troubles for many landowners in Andhra Pradesh. Corruption and collusion among government officials and real estate agents are the alleged reasons behind these, but they are negatively impacting many common citizens for no fault of their own. How can we try to minimize these hardships of the landowners in our country? What kind of reforms can we bring about to reduce these land scams? Will resurveying of land and faster updation of records work? Or is there a need for more accountability on the hands of the officials? Let us know your thoughts in the comments below.